Hi, this is Tiffany Dawson. I'm here to present about trusts. I want to give you a disclaimer that I will probably go a little fast, but I want to make sure we get all the content in this video. And if you have any questions, feel free to ask me at the end. So let's begin. A trust is a title of an agreement, basically to help transfer assets from one person to another or to an entity without going through probate. So here's an analogy to help put it in perspective. A trust is like a container. The container will then have instructions printed on the top of the on the top that state what they want done with the assets or the contents in the container. The grantor is the one that makes the decisions of what he or she wants done with the assets in that container. So they are also the ones that put the assets in the container. So here, or the assets are the contents. From there, the grantor also chooses who they want to be in charge of those assets when they pass away, or even when they're alive, depending on what type of trust is created. And that person is called the trustee. There can be more than one trustee of those contents of the container. The grantor also decides who will be the beneficiaries or one beneficiary of the assets in the container or the trust. And from there, the trust document will then indicate to the trustee what the grantor's wishes are and instructions for what will happen to those assets. The assets will then be in the responsibility of the trustee. The trustee then acts in the best interest of the beneficiaries and transfers those assets to the beneficiaries. Here, therefore, we've already covered the parties to a trust. A grantor is also called a settlor, creator, or truster. They create the trust. They initially put the assets into the trust. They establish the terms of the agreement, and they put who they want in place of managing those assets, the trustee, determining who the trustee is. And that is one of the most important decisions the grantor is going to make because they need it to be someone who they can trust wholeheartedly to do what they have asked in the trust document and to act in the best interest of the beneficiaries. The trustee, there can be more than one trustee. The beneficiaries, they're the ones that have the right to the trust, assets in the trust, and there can be two types, income or remainder beneficiary. The income beneficiary has the right to the current income or distributions of the trust, such as dividends or interest earned on the assets in the trust, and they can use those assets, that income right now. The remainder beneficiary is an individual or an entity that receives the principal or the original amount put into the trust plus all the capital gains. And that's the remainder is another way of thinking of it. Once the trust terminates, the assets remaining in the trust, that's what the beneficiaries will get. There can be the income and the remainder beneficiary can be the same person as well. Reasons that you might use a trust in the estate planning include managing property and assets. So if you know there's a beneficiary that you want to receive some of your assets, if you're the grantor, but you know that they don't manage very well their finances, then a trust, you can put the trustee in charge and still the beneficiary can receive those assets. It is also a way to have creditor protection. So there's a spendthrift clause that's placed in the document that protects against the beneficiary's creditor, except if the beneficiary is also the grantor and the trustee. So the beneficiary created the trust for their own benefit. That will not protect against any of the creditors of the beneficiary. You can also use it for split interests, like we said, income interest or the remainder interest. There's income beneficiary, remainder beneficiary, split interest. It's used when there's valuable assets that you don't want to split up amongst children and helps with the estate planning and wealth transfer goals. So if there's something where you want the children to receive the income from the assets, but you don't want them to receive the assets themselves or try to split it between them because they might have to sell something, then you can have maybe it put into an entity afterwards or have that in the instructions. Trust is also a way to avoid probate. And probate is the process where it collects and transfers the deceased property or pays off the debts and taxes that are due. And this is through the court system. It can be very expensive with attorney fees or any other costs that go along with the court system, and it can be very time consuming. Plus, the information is also public. So anything that goes on in the court system becomes public if concerning the wills or if there is not a trust. If it goes through the probate, that's what I'm meaning to say. If it goes through probate, information is public. So trusts also are a way to help minimize taxes, not a guarantee, but it is a way to help. So if there is an asset that would have future appreciation, it's a way to transfer that to the heirs and not have to pay tax on that appreciation. The grantor does not have to. There's also a way to reduce the size of the grantor's gross estate or decrease the transfer taxes for future generations, and also to reduce the income taxes for the donor or the grantor of the assets that provide income. There's types of trusts. One is an irrevocable trust where the grantor can make any changes or can cancel the trust anytime before they are incapacitated or they pass away. The revocable trust also avoids probate, and it helps provide for the management of assets if the grantor becomes incapacitated. And it can help when they do pass away also. But when they pass away, it becomes an irrevocable trust most commonly. An irrevocable trust means the grantor cannot make any changes, cancel it, or take back any of the property that was placed in the trust. This helps with gift and estate tax planning. The inter vivos trust is simply a trust that's created during the grantor's life. Sorry about that. The testamentary trust is a trust created after the grantor's life. So how does that happen? Well, the grantor created a will. The will then instructs the executor to create a trust in which the assets that were listed in the will go into the trust, and from there, the trustees are able to disperse the assets as instructed. All right. There's a standby trust. This is a trust created during the life of the grantor, hence inter vivos, but it is not funded, or it is very minimally funded because it waits until there's an event that happens to activate the transfer of the assets into the trust to fund that. And it's used during life, incapacity, or death. There's a pour-over trust where the assets are received from a different source, such as the grantor's estate at death, and it is unfunded until that situation occurs. The grantor trust can be irrevocable or revocable. It is inter vivos only, so only made during the life of the grantor, and the grantor pays income tax on the trust's income. So again, to go over funded or unfunded, funded means the property was received from the grantor and it makes the trust come alive. The trust document, if it's just drafted and there's nothing in it, that's unfunded. And it's not alive yet. There's nothing to it. It's just an empty container with nothing in there to transfer. So that's one way to think about it. There's simple or complex trust. A simple trust is one where the income is distributed to the beneficiaries every year, and the beneficiary cannot be a charitable organization. However, with a complex trust, You can have a charitable organization be the beneficiary, and it's anything that's not a simple trust. Kind of helps. So you can, in a complex trust, accumulate the income, or you can distribute it, the income. All right, so there's different purposes for using the estate planning. So we understand that it helps avoid probate. And here's the examples. On the left-hand side, you see a list of all the different types of trusts. And then on the right-hand side, you see, or partially on the right-hand side, but you see connected with that ways that it is used in estate planning. So I'll pull a few examples here. One is inter vivos revocable trust created during the life of the grantor, that the grantor can make changes. It helps avoid probate and it provides privacy. A bypass trust. It helps in the process of transferring that maximum allowable gift that is provided for individuals and couples. So it helps couples in that aspect if they have a lot of assets. There is also a qualified terminable interest property trust. That's basically giving the surviving spouse the right to the income. So these are just some examples. You can also use it to have the grantor receive a fixed percentage of the initial contribution, or transfer property or business at a discount. There's the ability to transfer artwork or antiques and jewelry to people that you would prefer to have it, and have that specific guidelines with it. And trust for minors, this might be something where if you have small children and you want to pass along assets to them in case something would happen to you, you would have the instructions on who's going to be in charge of those assets, because those children cannot receive them. They are a minor. And you could set the date or the age in which those children can receive those assets, or you can have it at 21 years old, which is the general age. There's another example of a special needs trust. A special needs trust allows, if you had a child with special needs, for example, and you want to leave some of your assets to them, but you don't want to interfere with the federal and state funding they receive, a special needs trust helps provide that, because it ensures that that funding is preserved and maintained. So these are just some examples. So from here, I want to help you determine and ask the question, what do you have to transfer and who do you want to transfer it to? Because from there, you can evaluate what information that was just presented applies to your situation, and then you can seek out a professional attorney, financial planner, or a financial advisor, or an accountant. That can be your team that will help you evaluate these options and how it would fit your situation. If the trust does become the best thing for your situation, you're going to have to determine what assets you want to go through the trust, who would be the trustee, and who would be the beneficiaries. So here's the time for question and answer. Does anyone have any questions? All right, if you do have any, then just let me know. Here's my contact information, and it's been a pleasure giving you this information, and hopefully it was very helpful. Thanks, and have a good night.